Hello all, welcome to the new Simply Put series by ICAS Academy. This is Priyanka Mahapatra, faculty at ICAS. So today we'll be having a discussion on the newspaper dated 22nd of February 2024. So coming to the text and the content section of the Hindu newspaper, one article was very important from our exam point of view about the financial devolution among the states. Then coming to the explain section of the Indian Express newspaper, another article was important about Justice Fali S. Nariman, who recently passed away, and we will be discussing some of the notable cases by him. So these are the two articles we are going to discuss today, which is displayed on your screen. So regarding the first article, that is on the financial devolution among the states. So why this is in news? Because recently various opposition ruled states, especially from South India, they have claimed that they have been not receiving their fair share as per the present scheme of financial devolution. So let's discuss what is the divisible pool of taxes. So we have generally a vertical asymmetry in the distribution of asymmetry in the distribution of resources or revenues and responsibilities between the center and the states. Often we refer that as vertical fiscal imbalances. So we have vertical asymmetry, that means there is a kind of imbalance between the center and the states where the central government is enjoying some of the most important and fast growing tax revenues like corporate income tax, personal income tax. On the other hand, the states have no such power to enjoy the vibrant tax resources, and all the more they have more responsibility to provide for the fast growing expenditures under the items like health. In fact, states generate around 40% of the revenue, whereas they have to bear 60% of the expenditure. So this is the asymmetry we are having. So to solve this vertical imbalance, the constitution itself from the very beginning given a solution in the form of Article 280, where it proposes the creation of Finance Commission in every 5 years to recommend the transfer of resources from the center to the states. Right? So we have a framework under the Constitution under Article 280 where we will be creating a finance commission in every 5 years to recommend the transfer of resources from center to the states in order to address this vertical imbalance, vertical fiscal imbalance. So what does the Finance Commission do? They review the fiscal conditions of the center and the states from time to time, and they suggest the resource transfer from the center to the states. So for the transfer of central resources, the Constitution itself points out that what kind of tax resources of the center has to be shared with the states. And these tax resources or sources of the center that must be shared with the states is known as the divisible pool. Understood? So the tax resources of the center which is to be shared with the states in order to address the vertical fiscal imbalance is known as the divisible pool. In the Constitution, we are having Article 270 which describes about the tax resources to be transferred from the center to the states. ठीक है? So Article 270 of the Constitution, it provides for a scheme of distribution of net tax proceeds collected by the union government between the center and the states. And what are the taxes that are to be shared between the center and the states? That is the corporation tax, personal income tax, central GST, and the center's share of the integrated goods and service tax. Okay, and this finance commission is under Article 280 of our Constitution. Apart from these share of taxes, states are also provided grants in aid as per the recommendations of the Finance Commission. So you all have read in your polity classes that Finance Commission is responsible for giving recommendations regarding the shares of the taxes and also the grants in need. And you must remember from your prelims point of view that cess and surcharge which are levied by the center, they are not part of this divisible pool of taxes. So this is one of the biggest issue. We'll come to that. So how is this finance commission constituted? It is constituted every 5 years, exclusively by union government. It consists of chairperson and 4 other members who are appointed by the President of India. So these facts are very, very important from your prelims point of view. Again, we have a act, Finance Commission Miscellaneous Provisions Act 1951, which specifies the qualification for the chairperson and other members of the commission. So it's not written in the constitution, it is not defined in the constitution regarding the qualification. We have a legislation regarding it, okay, that you must remember, okay, regarding the qualification of the chairperson and other members of the finance commission. And recently, Union government has notified the constitution of 16th Finance Commission under the chairmanship of Dr. Arvind Panagaria for the making its recommendation for the period of 2026 to 31. So now what is the basis for the allocation of the taxes? There are two things, vertical devolution and horizontal devolution. Vertical devolution means the transfer from center to the states. This is 41% according to the 15th Finance Commission. So according to the recommendation of the 15th Finance Commission, the share of the states from the divisible pool, that is the vertical devolution, stands at 41%. And how then the distribution between the states is going to happen? That is based on various criteria, as you can see in the table here. So according to 15th Finance Commission, there are various criteria. Income distance is having the highest weightage here. Then the population criteria is also there, 2011 census. Then the area, right? Then the forest and ecology criteria is also given. Then demographic performance and tax effort. So these are the criteria based on which the states will be given their fair share of taxes. So according to the 15th Finance Commission, income distance. What is this income distance? It is the distance of a state's income from the state with highest per capita income, which is Haryana. So Haryana is the reference point which is having the highest per capita income and the state which we are considering. So the difference between the two is the distance, is the income distance. And states with lower per capita income would be given a higher share to maintain the equity among the states. Okay, so this has been the philosophy. To maintain equity among the states, the state which is having lower per capita income will be given higher share of taxes. Then comes the population. Here according to 15th Finance Commission, 2011 census is the reference point for the population criteria. Till 14th Finance Commission, we were considering the 1971 census, but it has been discontinued in the 15th Finance Commission and 2011 census has been considered. Coming to forest and ecology criteria, they consider the share of dense forest in each state in the aggregate dense forest of all the states. Okay, so the share of dense forest of each state in the aggregate dense forest of all the states. That is how the points are calculated. Then the demographic performance criterion has been introduced this time in the 15th Finance Commission to reward the efforts made by the states in controlling their population. The states with lower fertility ratio will be scored higher. For example, the southern states. So it is a way of rewarding the efforts made by the states in controlling their population. Then comes the tax effort. That means this criterion has been used only to reward the states with higher tax collection efficiency, right? So what are the issues with regard to the financial devolution among the states? First is that we discussed that the cess and surcharge which is collected by the union government, this is the exclusive power of the union government to collect the cess and the surcharge. Okay, and this is estimated at around 23% of its gross tax receipts in the year 2024-25, which do not form the part of divisible pool. Okay, so this is the main problem, that the cess and the surcharge, they are not to be shared with the states. For example, states have no control over the components of GST compensation cess. Though GST compensation cess is used for the benefit of the states by the center, okay, to compensate states for the shortfall in the tax collection due to GST implementation for the year 2017 to 22. Okay, so this cess was been used to compensate for the states who are facing the shortfall in the tax collection in the period of 2017 to 22. And also some of these amounts are also been used for centrally sponsored schemes for the benefit of the states, but the states are not having any control over the components of the GST compensation cess. It is the center which is deciding that. Again, the state's share is around 32% only of the total tax receipts of the center, which is way less than what is recommended by the 15 Finance Commission, that is 41%. This is another issue. Then third issue is that industrially developed states such as Maharashtra, Karnataka, Haryana, Tamil Nadu, they are receiving much less than a rupee for every rupee they are contributing. They are receiving much less than a rupee for every rupee they are contributing to the central government, while other states like Uttar Pradesh, Bihar, they are receiving more despite less contribution. Reasons why the industrially developed states, they are able to generate more, because many large corporations have their headquarters in the major industrial cities like Maharashtra, Tamil Nadu, Karnataka. So their companies, they pay huge corporate income tax due to larger economic activity there, but they are not seeing the full benefit in terms of tax revenue. The states are not seeing the return. Why is that? We'll discuss now. Again, the GST collection is one of the other reasons, because GST is a consumption based tax, destination based tax, meaning it is levied on the final sale of the goods and services. So states with higher economic activity, again the major industrially developed states like Maharashtra, Tamil Nadu, so they have their higher economic activity going on there, they have their higher consumption, leading to more of the GST revenue. So these industrial developed states, they are contributing more because of the location of the corporate headquarters and because of the GST collection. But their share is reducing day by day. The percentage share in the divisible pool of the taxes has been reducing for the southern states over the last 6 finance commission. You can see in the graph. You can see Tamil Nadu graph, you can see Karnataka graph, how it is reducing, how it is in the downward trend. You can see Kerala graph, vis-a-vis Rajasthan, Uttar Pradesh, Bihar. Hence the southern states, that is the industrially developed states, they are complaining that they are not receiving what their fair share has to be. Because despite their efforts in demographic performance in the tax effort, their weightage being less in the criteria table, that is not reflecting in the fair share of the divisible pool of taxes, because the income distance, the population, the area, the forest and the ecology, they are given more weightage. Understood? So higher weightage has been given for the equity, income gap, the population, area, forest than the efficiency, that is the tax effort and the demographic performance. So that is why the southern states, despite showing their good performance in controlling the population or good performance in the collection of the taxes, showing efficiency in the collection of the taxes, but that is not reflecting in the larger share of the divisible pool of the taxes. So these industrial states, they are receiving way less compared to what they are contributing. Again, grants in aid, that is also varying among various states. So there are various specific grants, there are various grants in need like revenue deficit grants, sector specific grants, state specific grants which are given to various states and grants to local bodies. But these are based on the population and area of the states again, where states like UP and Bihar, they are at an advantageous position because of their higher population, because of the area of the states there. ठीक है? So these are the major issues with regard to the financial devolution of the states and why the southern states are complaining about. So what is the way forward? What is the solution now? First is that we need to rationalize the cesses and the surcharges on two fronts. First is that the divisible pool can be enlarged to include some portion of the cess and the surcharge in it. And on the second front, Centre can think of gradually discontinuing various cesses and surcharges whose purpose has been solved, whose purpose has been met. Okay, then coming to the efficiency criteria, the weightage for the efficiency criteria, that is the tax effort and the demographic performance, should be increased in the horizontal devolution of the taxes. Thirdly, states which are having higher consumption, they are contributing more through the GST. So this has to be considered in the Finance Commission recommendations in order to promote equity and address these fiscal needs of the states who are contributing more. Then lastly, similar to GST Council, we need to have a more formal arrangement for the participation of the states. Okay, in the constitution and the working of the Finance Commission. Then more than this, it is very important for the states also to uphold the principles of fiscal federalism by devolving adequate resources to the local bodies for the vibrant and accountable development. So these points were very important from your mains perspective if any question is coming with respect to the financial devolution among the states. So this becomes very important from your GS paper 2 syllabus. So next article is about Justice Fali S. Nariman, who recently passed away. So we'll be discussing some of the notable cases with respect to him. First is regarding the Kaveri water dispute, state of Karnataka versus state of Tamil Nadu. So over 30 years, lawyer Nariman, he had fought for Karnataka in a water sharing dispute with Tamil Nadu. In 2016, the court ordered Karnataka to release water to Tamil Nadu, but the state of Karnataka refused. So Nariman, who was representing Karnataka for so many years, he disagreed with the state of Karnataka's action to refuse the release of water to Tamil Nadu and said that he will not be representing the state of Karnataka. So the court, the Supreme Court, appreciated this honesty of him and reduced the Karnataka's water share as punishment. Then we come to the second article, which is talking about the governor to act only upon the aid and advice of the Council of Ministers, headed by the Chief Minister. So what happened in 2015? A group of lawmakers in Arunachal Pradesh, they rebelled against the ruling party. And here the governor, it tried to call for an early assembly meeting to decide who was in power. But the lawyer Nariman, he stood against this act of governor and said that it is not the power of the governor to do this. He needs the aid and advice of the Council of Ministers headed by the Chief Minister. And the Supreme Court also agreed to this viewpoint. He said that governor has to follow the constitution and listen to the elected government. And this is how the original government stayed in power. Then comes the third case, that is the right of minorities to establish and administer education institutions in the case TMA Pai Foundation versus State of Karnataka, where Justice Nariman argued in the landmark TMA Pai case in support of the minority rights to establish their educational institutions, administer their educational institutions under Article 31 of the Constitution. And in this case only, it was decided that the linguistic and the religious minorities, they are to be determined on a state to state basis. That means the minorities needs to be identified within each state, not nationally. And the government can make rules for these educational institutions, but the rules cannot stop them from being minority schools. So the government can have the power to frame regulations which will apply to these minority run educational institutions. They can very much make rules for these educational institutions, but making the rules cannot stop them from being called or being considered as minority educational institutions. That means these regulations cannot destroy the minority character of the institution or make the right to establish and administer a mere illusion. Okay. Then comes the Bhopal gas tragedy, that is Union Carbide Corporation versus Union of India 1989. When the Supreme Court began hearing the case for compensation to the victims in the year 1988, Justice Fali S. Nariman was the senior advocate then. He was representing the Union Carbide Corporation, and he offered to pay a sum of $426 million as compensation to the victims of the tragedy. And lastly, in 1989, it was reached to a settlement with the central government and agreed for the payment of $470 million as compensation. So this was under the oversight of senior advocate Nariman. Then comes the fifth case, that is IC Golaknath versus State of Punjab, where it was given the ruling that Parliament cannot curtail fundamental rights. So what happened in this case? When two brothers in Punjab, they challenged the Punjab Security and Land Tenures Act 1953, which imposed certain land ceiling restrictions, which weakened the property rights of the citizens. So these two brothers, they argued that this law by the Punjab government, it is violating the right to property enshrined in the Article 19(1)(f) of the Constitution. And also, Parliament had passed another Amendment Act of 1964, 17th Amendment Act of 1964, which exempted this Punjab Act from judicial review based on fundamental rights. And the Supreme Court ruling was that the Parliament's amending power is not absolute. It cannot abridge, it cannot take away the fundamental rights. And the 17th Amendment Act, which was brought by Parliament, was declared null and void because it violated Article 13(2), which restricted the Parliament from making any law which violates the fundamental rights. So this Golaknath case is very, very significant in the view that it protected the fundamental rights. It limited the Parliament's power to weaken these fundamental rights through amendments, and in the way it introduced the basic structure doctrine in the future, where the Kesavananda Bharati case overruled this Golaknath case, because this Golaknath case was giving absolute protection of the fundamental rights. But the Kesavananda Bharati case brought the basic structure doctrine, keeping the societal dynamics into picture. Okay, it ensured that certain core principles of the Constitution to remain immune from change, but we can amend the Constitution sometimes according to the societal dynamics. Right? So this was all about the Golaknath case. Then comes the last and the most important case in which Fali S. Nariman was involved, that is the National Judicial Appointments Commission case, where Nariman represented the Supreme Court Advocates on Record Association, where he said that NJAC, National Judicial Appointments Commission, would impinge upon the independence of judiciary, where the central government and the legislature were allowed to participate in the selection and the appointment of the judges. Therefore, it was struck down, and the collegial system for the judge appointments were reinstated. So this was all about today's discussion. The short notes of this video discussion will be provided in our Telegram channel, and the link for joining our Telegram channel, the Kalam IAS Academy, will be provided in the description box. So do join our channel for the all important posts and updates. Till then, goodbye, take care, happy learning. Thank you so much.